Welcome to the Politics and Media Show with me, John Rees. Extending secret hearings into civil courts will undermine effective security of government operations in the so-called war on terror. This is according to prominent civil liberties activists and lawyers. The proposals will prevent claimants being told of the evidence against them and have been introduced in response to claims brought by those who have been mistreated or detained at Guantanamo Bay. However, the Justice Secretary, Ken Clarke, has defended the plans by insisting that closed material procedures, CMPs, will only apply to a tiny number of civil cases in very limited circumstances. Before we start today's discussion, let's take a quick look at the plans in more detail.
In a statement sent to the Islam Channel, the Justice Department outlined plans contained in the Justice and Security Green Paper. We have a growing problem in this country where individuals are alleging government wrongdoing, but the courts do not have the tools they need to get to the bottom of the matter. The reason for this is that the evidence on which the case rests is either intelligence material given to us by our allies, which we have promised not to reveal, or it is material which could reveal the identity of sources or damage our ability to keep the public safe. This means that the government is unable to defend its actions if the material has to be given in open court. It means that the claimants are left without any clear judgments by a judge based on all the relevant information. And most importantly, it leaves the public with no independent judgment by a court on very serious matters. We are therefore consulting widely on our proposal to allow sensitive evidence in this small number of cases to be argued before a judge in a closed court, with the safeguards needed to protect public safety. This is a common-sense solution to a serious problem. But in a recent high-profile criticism, the Director of Liberty, Shami Chakrabarti, the Conservative MP David Davis, Lady Kennedy QC, the former Director of Public Prosecutions Lord MacDonald QC, and others, warn that the government's Justice and Security Green Paper violates basic principles of common law. The worst excesses of the law on terror were revealed by open courts and a free media. Yet the Justice and Security Green Paper seeks to place government above the law and would undermine such crucial scrutiny. It will permit the extension of closed material procedures, in which claimants and their lawyers are excluded from court and refuse sight of government evidence to any civil claim whenever a minister considers that openness is against the public interest. This violates two of the most basic principles of our common law system: the right of every party to know the case against them so that they can answer it, and the principle that there must be equality of arms between parties in court. It will permit secret hearings and the giving of secret judgments by courts, accessible only to the government.
Well, with me to discuss this is Nick Pickles of Big Brother Watch, an organisation which was set up to challenge what it sees as the policies that threaten our freedoms and civil liberties. And on the phone we have Corey Crider of Reprieve. We also did invite the Justice Ministry to participate, but they declined. Corey, let me come to you first. How serious a challenge is this to civil liberties?
It's extraordinarily wide-ranging. The government says that it's only going to be a narrow category of quote-unquote national security cases. But if you look at the Green Paper, that's not what they say. They say that they can go into secret hearings any time a minister says that it would be in the public interest, quote-unquote. And in any event, if you think about the torture cases that have arisen and indeed continue to come out into the public domain from the past several years, they're precisely the sort of cases that even under the supposedly narrower national security standard, the government is now seeking to punt into secret. What that means, just to put people have not paid enough attention to this Green Paper, I think, because it's written in a very lawyerly way, I think deliberately to avoid attention. But let's be clear about what it means. What it means is that if a man in the community or woman comes forward and tries to sue the security services and says, the British security services have been involved in my torture, it is possible, if the law changes the way the government wants it to change, that the government will put in a certificate, say, thank you very much, the entirety of the case has to be heard and closed. The poor person's open lawyers will make whatever submissions they can. The open argument may even seem to go well for them. And then it may happen under this new law. It may happen that the court would come back and say, open arguments were very effective, but for the reasons I have given in a closed judgment, the claimant loses. Now, I have to say, I'm an American, but I think that's just anathema to what British justice is supposed to stand for.
And do you think that the kind of entirety of these proposals are going to make their way from the Green Paper into a White Paper, or do you think that the opposition is such that they may have to retreat on this?
Well, it's a classic governmental tactic to anchor high, isn't it? To ask for something that's patently unreasonable, and the understanding that as it makes its way through to being a bill, it will be salami sliced into what the security services really want. But make no mistake, what the security services really want is that cases that are immensely in the public interest will be heard in secret. And anybody who says that this is only about the Guantanamo Bay civil claims, and we already know what happened in those cases, so does it really matter? It hasn't been reading the news. Late last year, it became clear during the Libyan revolution that MI6 and the British security services were centrally involved in the rendition not just of 2 Libyan dissidents, but their wives, and in one man's case, their 4 children, back to the Gaddafi regime. Those people are now bringing a case against the UK government for its role in their rendition to torture in Gaddafi's Libya, but that's precisely the kind of case that will be kicked into secret if the law goes through, even in a kind of salami-sliced, putatively reduced form. That's, make no mistake, that's what they're trying to get rid of. They want these cases to go away. It's embarrassing for them. They have to settle them because it makes the security services look very bad indeed, not because they're innocent, but indeed because they're not.
Well, thanks very much, Corey. Nick, do you agree with that assessment that the proposals in the Green Paper are a serious threat to civil liberties, and that they're not something that marginal will happen only in a few cases, as the Justice Secretary is saying?
Corey's absolutely right. The way the proposals are drawn in the Green Paper, this would cover any civil case against the government, so not those limited to the cases directly involving the security services, but, for example, it could involve inquests. Now, in the past few years, we have had several investigations undertaken by coroners about the equipment British troops have, about the incident that led to the loss of a Nimrod plane and the death of several RAF servicemen, and also the things like the 7/7 inquest that have dealt with sensitive intelligence issues. But it's been very important for those examinations to take place in public, so that the public can have confidence that not only is justice done, but justice is seen to be done. The way the Green Paper is drawn, it risks capturing so many cases which are not directly related to national security. And I think your point is absolutely right. I think the government has made a tactical consideration to cast its net very, very widely in the hope of seeming reasonable when it comes out with a compromise. But I think you've just heard from Corey there, and from Shami Chakrabarti at Liberty, and ourselves and a whole range of groups, this is such a broad proposal. There is no turning back. This is a direct affront to British justice.
And presumably, I mean, in a way, the government's room for retreat, so to say, is quite limited, because they've made a proposal which they say is only going to apply in a minority of cases, or a tiny minority of cases. If you retreat from that, you haven't got any cases at all, presumably.
Well, and there's actually a fundamental principle at stake as well that the government hasn't been talking about, is the way that the process is reached to exclude evidence. At present, there is a procedure known as a public interest immunity, where the government can ask for evidence to be kept out of court, but that decision is made by a judge. So the government argues and makes its case, and the judge balances the harm done to open justice against the harm of disclosing the evidence. In the current proposals in the Green Paper, that responsibility would lie with the minister. So you have a political figure deciding if evidence should go into court, and the only way of challenging that decision is by judicial review, which is actually focused on the process of reaching the decision, not necessarily whether the actual decision itself is right.
So is there some opposition among the judiciary itself to this, because it's stripping powers away from them and giving them to political figures?
Well, you've heard that a former director of public prosecutions has come out quite strongly against the Green Paper. You also have the special advocates, the people who are currently working in the very, very tightly defined examples of, for example, immigration cases, and also in control orders and these TPIM orders. And they are almost unanimously against the extensions in the Green Paper. So the actual people working in the courts are saying that this is a serious problem, and indeed one judge in a recent case before the Supreme Court said quite simply, evidence that has not been challenged in court by both sides may actually mislead the people making the decision about the lawfulness of the government's acts.
And secret trials essentially are not only a danger to civil liberties in the sense that the judicial procedure is hidden, but it's hidden from the press, and these are very political cases. So in a way, the suspicion grows that the government is suppressing unfortunate political or inconvenient political news as well as a justice system.
And indeed, we've already actually heard of cases in the control order system where provisions made to redact sensitive material were actually used to redact material that was not sensitive, but was embarrassing. And so when you've already got that system in place where a judge was able to say, I'm sorry, but I do not believe that you've redacted that to protect national security and you have redacted that to protect your own reputation, then I think that's a very dangerous step to take when you start saying that you will no longer give a judge the power to scrutinise a decision and instead leave it to political officials who ultimately will make political decisions. And if they think it is in the best interests of their own political interests to have information held in secret and for their decisions to not be scrutinised in public, then the likelihood is they will take those decisions. We need a balance on that, and that's the role of judges. The Green Paper takes that role away.
And, I mean, Corrie was making the point that these cases aren't simply about the past and about Guantanamo and so forth and so on, but there's an ongoing problem here, as she said, isn't there?
Absolutely, and the war on terror continues apace. The security rhetoric around the London Olympics and the Arab Spring, we still see very, very difficult times ahead. And it's important that security services do have the tools to do their jobs properly and to protect the public. But that shouldn't extend to giving the security services carte blanche to do what they see is fit in the circumstances, rather than being held to the same standard of legal behaviour they have been in the past. And I think the very disappointing thing about the Green Paper is that Britain went through a very, very dangerous period in the 70s and the 80s with the Troubles in Ireland. And our justice system coped with them. It coped with the need for some evidence to not be made public. It coped for the issues around the identities of informers and indeed the security services. We came through those troubles without sacrificing our judicial system and the principles that have held the British system together for centuries. And now there is a renewed attempt to rewrite the rules. Yet the Green Paper cannot offer one case where it says the existing rules were insufficient. And indeed, the case last year, which has led to the Green Paper, the actual existing public interest immunity test wasn't even explored to the full extent of the law. So this change is not legally needed, and at the same time threatens the future of our legal system in an unprecedented way.
And you might want to make the point that actually, insofar as there have been failures in the war on terror, they have actually been within the security services. I mean, over 7/7. But if we look at the shootings in Toulouse, it isn't that this individual wasn't on the security services radar. They very definitely were. They just failed to act on the information that they possessed, or to understand its meaning, but it didn't really reside in. My point is that it didn't reside in failures in the legal system.
And I think the danger is that we start to see perhaps failures in the intelligence community or poor decision making as a reason to change the legal system for how we measure those decisions after the event. I think in Toulouse, in 7/7, and obviously Jean-Charles Domenech, there were very, very important issues to be addressed, because ultimately, if we're going to keep the public safe, the security services, like any organisation, need to learn from their failures. And it's very important that the public can have confidence that when things do go wrong, behaviour is changed and lessons are learned. And the media debate and the public debate is a very important part of the process as to how the public trust the security services to keep us safe. And so when they do ask for more powers, that's seen as a reasonable request, and not as, unfortunately, as the Green Paper has become, a very unreasonable and disproportionate attempt to fundamentally change the way the British justice system operates.
So what you're saying really is that besides politicising the justice system, besides giving the power to make these decisions to politicians rather than judges, to ministers rather than judges, we will also end with a system where the elements of accountability that exist, insofar as they exist with the security services, will be withdrawn. So you're really moving towards a kind of lawless and hidden security service.
Well, the risk of the security services being above the law, quite simply, if you can't challenge in court evidence provided, and in some cases this will be very, very complicated, but for example, under the current regime, security services could assert that you were in a certain country on a certain date. You may have a perfectly legitimate alibi that says otherwise, but if you're not aware that the security services are making that allegation in the first place, how do you rebut it? And that's a very, very dangerous precedent to set, that no longer is evidence being provided by the security services open to be challenged in court. I think it's important to note that this Green Paper actually applies to civil cases. So there is obviously a separate system for criminal prosecutions. And this is a very important distinction, because criminal prosecutions are about prosecuting people for wrongdoing, and civil cases are about seeking recompense for where wrongdoing has been doing against you. So there's an awful lot of people who, in any circumstance, not just national security, may want to take legal action against the government because they feel the government has failed them. And the Green Paper would seriously alter the balance of power in those cases, where people are seeking fair and perfectly reasonable compensation for something where the government was in the wrong. Whether that's the health service or the security services, it's an important principle that you can seek justice when you've been the victim of wrongdoing.
So in other words, by making this specifically about civil cases, the government's argument that it in some way compromises the war on terror and so forth, it isn't dealing with the perpetrators. It isn't dealing with the people who are bombing or whatever. It's only dealing with people who have been mistreated by the legal system, perhaps have been wrongly accused by the legal system. So it's hard to see where that particular argument stacks up with the civil cases in particular, isn't it?
Well, I think the issue is that the government wishes to defend itself, and as taxpayers we would all hope the government does defend itself where people are seeking compensation to make sure those claims are justified and that the compensation awarded is proportionate to the harm suffered. But ultimately it does come down to government being held accountable for its actions after the event. If mistakes are made and people suffer as a result of those mistakes, then it's perfectly reasonable that they should be able to seek redress for that. And the Green Paper risks undermining your and I's ability to hold the government to account, not just in national security cases, but in any civil case. So the public interest is defined very broadly in the Green Paper. And one of the dangers there is that things like the economic well-being of the country becomes part of the national interest. So suddenly, cases that perhaps only very fleetingly involve the security services are caught up in a procedure which the government itself recognises is only relevant in a tiny number of cases. And indeed, many of the examples where the government says the system needs to change are actually hypothetical.
So if you broaden it to this extent, and as you say, bring in the question of the economic well-being of the country, this might then begin to apply in industrial cases. I mean, we've had some recent news items about blacklists have been run of trade union militants. If these were government bodies and there was redress against them, then this might fall under that kind of remit.
Well, the blacklist issue is an excellent example of where the security services were involved in something that is now being deemed to be unlawful. But the legal process for holding that to account would be made much, much harder if key evidence and key material was excluded from that. And as we go towards the Olympics now, the interest of protecting the public and the use of national security as a reason for doing things becomes much broader. And you do start to see situations emerging where things where the public safety has never been an issue suddenly get caught up in this problem, and then the government is able, for reasons not connected with keeping the public safe, to use this catch-all defence of the that the material should be held in secret and not open to scrutiny in court, and is not having to seek judicial approval for that decision in the first place. And that's a very important and very dangerous change that the Green Paper proposes.
Well, thanks very much for that. We'll be discussing another important issue, the place of Sharia law in British legal system, in the second part of Politics and Media. Please do rejoin us. Welcome back to the Politics and Media Show. In media comments that have now been withdrawn, it was reported that stoning, whipping and amputations could become common punishments in Britain if Sharia law is allowed to grow in the UK. That was apparently the stark warning made by a British peer last week. It had been reported in The Sun and the Daily Mail that crossbencher Baroness Cox claimed that a rise in the number of British Muslims using it instead of the official court system could even lead to the destruction of British democracy. But now the papers have withdrawn their reports on Baroness Cox's speech at the Christian Broadcasting Council symposium at the House of Lords, in which she was warned that a threat of Sharia law in the UK could be growing. The move came after a complaint by the Baroness that she didn't make the comments. She also says that The Sun has now apologised to her for the report. Well, with me to discuss the incident and to place it in context of Sharia law in the UK is Barrister Ahmad Thomson, Wynne Chambers. We have Amra of Birmingham Sharia Council, and Alan Craig, who works in the Baroness Cox's parliamentary office and is here today to represent her. He's also leader of the Christian People's Alliance. Welcome to you all. So, Alan, given that you're the Baroness's representative here, she didn't say it, and in any case it's a storm in a teacup, isn't it?
Yes, I think it probably is. I think she certainly didn't say it, and it would be irrelevant. I've never heard her say that. I wasn't actually at the discussion on that particular day. I was actually out of the country, but it is clear I have read her speech, although I gather that the response that was made wasn't actually a response by her. It was made during the question and answer session afterwards. But whatever, those aren't her sentiments. I do know that. And while we may have floggings and amputations in Saudi Arabia and other notorious countries, we don't have them in this country, and there's no proposition or possibility of them coming here. So yes, a bit of a storm in a teacup.
Oh, Thomson, even the idea that in some less gory way that Sharia law is a threat to the British legal system even is overstated, given that it's a voluntary procedure and stands within the framework of British law.
It is. I mean, I've sort of read up a bit on what Baroness Cox has been saying, and I'm quite amazed actually, because she makes statements about the Sharia which are completely not true. So she doesn't seem to have done her research, and also she misrepresents what the Sharia councils are doing. And in fact, they are, on the whole, performing a very valuable service and providing a service which the legal system, the English legal system, does not, at the moment, provide. In that, on the whole, most of the cases the Sharia councils deal with are to do with ladies coming to ask for a marriage to be terminated because the husband will not give the talaq. She doesn't have to have permission to come to the Sharia council. And in most cases, they will give the khula divorce, which she asks, and she's then free to move on instead of being left in limbo. This is exactly the same situation as happened in the Bet Din. And I think in this context also, bearing in mind the bill that she's put forward, her private member's bill, one has to remember that it's going to impact on the ecclesiastical courts and on the Bet Din. The ecclesiastical courts have been running as a parallel jurisdiction in private law matters to do with the religious community since about the 3rd century AD. And certainly the Bet Din have been in existence since about the 12th century. And there's even in Westminster Abbey one of the earliest deeds evidencing a decision of a Bet Din of that time. And therefore they are going to be affected by this bill. And I think for this reason it may well be that when it comes to the second reading, the Minister of the Crown, who is in charge of making a statement of compatibility with the Human Rights Act, will have to say, I'm sorry, but this isn't compatible, because it's denial of the Article 9 rights of the Muslim community, the Jewish community, and the Christian community. And I think maybe her proposed bill is impacting more than she realizes. Certainly Section 3 of the Human Rights Act says that where Article 9 rights are engaged, courts must give special regard to them, and i.e. that they are protected. And it seems to me that this bill, really on the basis of, I would call flimsy evidence. I mean, she's taken some bad luck stories, often from the Shia community, who, for example, permit mutta marriage, temporary marriage, whereas the Sunni majority of Muslims in England, and certainly all the Sharia councils, do not recognise that as a valid marriage. And also, it's interesting to note that there is no Shia Sharia council, and I'm not aware of Shia ladies or men coming to the Sunni Sharia councils for any kind of assistance.
Mm. Amra, most of the cases heard here are family matters, aren't they?
Absolutely. I mean, I'm representing Birmingham, the Sharia Council, which is based in Birmingham Central Mosque. I mean, in fact, it was set up to help a community, particularly women, meet a need which, as Brother Ahmad said, that it wasn't being met, so the women could not go to the civil courts. So the Sharia councils were set up to help the women. We have 15 to perhaps 16 cases every month. Majority of them are women, but we do have at least 10% who are men coming to the Sharia council. Now, they are there because they feel they have nowhere else to go. And majority of the women who come to us actually are treated very fairly. We take their evidence. It's not that we take them as half witnesses or anything as such, which is what's being propagated in the media. And women are treated as equal human beings. Most of them are unaware that if the marriage wasn't registered, that they would have no recourse to the law. Unfortunately, that is the case. We have thousands and thousands of marriages out there where have not been registered. How are we going to deal with them? And if women are, they cannot move on with their lives, which is both very unhelpful to them and to our society. So I think the Sharia councils are being misrepresented. I mean, we did have somebody contact us from a researcher from Baroness Cox, a researcher who came to us, sat there, listened to for the whole day, and she did write an article later on, but it wasn't really, it was just a very, it was like a report about the Sharia rather than about ourselves, which I was sent later by someone else. So she did say she'd heard good things about us. As you know, good news do not make news. We have hundreds of women out there who are very grateful and thankful that she's been, able to move on with her life and has it resolved. And I mean, to let you know how things are done Islamically, it is a woman has every right. We often tell her that there is nothing that can stop her. Neither can we or her husband or anyone, should she not want to live with him. She has a right to choose to live with whoever she wishes to do so. And unfortunately, what I've read in the papers or on the internet, it does not make sense at all. We do not have any backing. They're totally voluntary. That's explained to them when people come. We have no real resources. A lot of the people who come to us cannot afford to pay us. So, it's I think.
Well, let me just bring Anna Craig back in here a moment. So, what's wrong with this? With this picture, these are voluntary associations. There are many, many forms of arbitration in the society that don't necessarily fall within, and perhaps should never fall within the ambit of the criminal justice system and the courts. What's the problem?
Sure. I mean, it's clearly a complex issue, and the whole issue about freedom of religion is a really important issue. It's an important issue in our democracy and so on. But I think I would summarise the comments made by my people here as smooth words, but a fair amount of nonsense, really. It is true that the majority of people going to Sharia councils are women, but that's because of iniquities between the ability to divorce by men and by women. They don't have the equal rights, and equal rights is a very important principle in British civil law and in all British law now. Yet it isn't true. A woman doesn't have unilateral rights to pronounce talaq 3 times and then gets a divorce. She has to go to a court. But also it isn't fair to say this is just a matter that Baroness Cox has been looking at Shia courts. She hasn't, and we haven't as part of her team. We've been looking at a number of different courts, the way they've been operating, and of course there are some 80 or maybe more Sharia councils, as they're better called, in the country, and they vary. Of course, they vary. Some are much more progressive and much more liberal, and some are much more traditional and conservative, and so on. But some of the big name ones, or those that have high status, have some pretty, from an English law point of view, some pretty worrying stuff. For instance, if we go to the Islamic Sharia Council, you can go to their website now. You could check it out and check out what I'm saying. They justify why the testimony of a woman is only worth half that of a man. They justify it and explain it in terms of women's characteristics and so on. Well, that simply isn't acceptable.
No, hang on a second.
Let me finish my point. You both had a fairly long go at it, and I'd like to say so. So you can see it there on their website. That's one of their fatwas which they stand by and justify as admittedly one of the more conservative Sharia councils that there are. But there are other aspects to the Baroness's bill, and we ought to say from the beginning that the bill is up for consultation, is up for amendment, is up for improvement. There's never been any doubt about that right from the beginning. And we've been undertaking a long process of consultation ever since the first reading, which took place in June last year, and consulted particularly with Muslim women's groups. And we've taken endless pain to consult with them, to talk. They've come to the House of Lords, we've been to them and so on to hear their views. And it's really interesting to know that there are many Muslim women, and because the issue was raised, many Jewish people as well, who are very much in favour of the bill, because they see that the whole gender equality drive behind the bill. And that's the specific area that it's aimed at, or mainly aimed at, not only aimed at that, there are also children's issues as well. But the main drive is on gender equality. And it's the areas of disjunction between what is now British civil law and Sharia law, and trying to deal with that, even though allowing for the fact that if a woman in full knowledge of the fact chooses to go for Sharia council decisions, she can still do so.
I mean, could I just put one thing straight, one record straight, because it's very important, this thing about testamentary capacity. The Sharia, as with the Jewish Sharia or the Jewish law, makes a distinction between attestation and giving testamentary evidence as a witness. So, for example, in terms of a commercial contract to do with a loan or a business deal, under the Sharia it requires either the witness, 2 male witnesses, or instead of a male witness, 2 ladies. And it says in the Quran, this is in case if one forgets, the other can remind her. Which is, there's no harm in that. It's giving certainty. Under Jewish law, the woman cannot act as a witness to a document. It's only males are allowed. Why is Baroness Cox not talking about that? Now, the next
that particular point.
Well, if I could just carry on, then the next thing is, as far as giving evidence is concerned, then the usual principles of credibility will apply. So, for example, if I look at the evidence that Baroness Cox has presented, saying, well, this is what the Sharia says, she doesn't quote one ayat of Quran or one hadith in support of what she's saying. And so I say, well, she's entitled to her opinion, but she doesn't actually seem to be basing her statements on Sharia on what the Sharia actually says.
She's basing her statements
briefly, Alan, then I'm going to bring Amra back in.
2 points. But basically, she's basing her statements on the experience and the behaviour rather than wanting to discuss theology with Muslims. She's not what we would call theology, in the sense that she's not discussing the Quran, she's not discussing the Hadith. Those are matters for Muslims and their own private religion. What she is looking at is the outworkings of Sharia courts and councils.
In the formulation of the bill?
Sorry?
There are no Muslims working with you in formulation?
Absolutely, there are. Yes, a number of them working with us, absolutely on the side, primarily Muslim women, I must say, working on the side. And
actually writing the bill?
Well, no, one lawyer wrote the bill. So, but they're part of the consultation process. It's been right from the beginning. We have wanted to hear the voices of Muslim women.
How many Sharia councils have you consulted with?
Okay, well, let's hear the
I mean,
woman that we actually have on the panel, Amra.
It sounds as if, you know, this is, you know, codified Sharia. We've never had that in history. I mean, if even you go back to the example of British in Egypt, there was a question raised that whenever the British said, whenever we go to the Muslims and we ask them an answer to Sharia, there's never one answer, and we want yes or no. So please give it to us as codified, and the Muslims absolutely refused that. That was never the case in history, and it's not going to be the case. What Sharia is about, it has a clear objective, which is to bring about justice, not a clear demarcation in terms of codification. It depends on the circumstances, cases, context, and that's how we deal with it. We use and particularly in our Sharia Council, we use the guidance given in the Quran and in the Hadith, and we take our context into account and then apply that. It's not just, you know, here we are, apply it and do injustice. In fact, it is meant to be for the women. I mean, why didn't they have recourse to the law in the first place? And they wouldn't have had to come to the Sharia councils. Now, despite the fact that, having said that, we do get cases where women have been to the civil courts, have had absolute decrees, but still come to us because they want things done in the sight of God.
Well, let me put that point to you, Alan, because it's a bit rich, isn't it, when you look at the British legal system, to start lecturing the Sharia councils about their gender equality protest. Many women would say, look, the way in which rape cases are dealt with in the British legal system is a disgrace. The way in which domestic violence cases are dealt with in the British legal system is a disgrace. So why isn't the concern here with the mainstream legal system as much as with the Sharia councils?
Well, let me answer that first. But I'd like to comment something about the best-in courts, which is quite an important point and actually a key to the legislation that Baroness Cox is promoting. But yes, but the principle is equality. The principle is gender equality in English law. The outworkings of that, of course, I can make all sorts of criticism of British law. I can make criticism of some of the principles, but the one which most people would buy into is there is equality between the gender, indeed equality between all people before the law. That may not work out in practice, but that's something that needs to be corrected. But that's an important principle which we don't identify.
So it may even be in this case. That it may even be that what we've got in the British case is that in theory it works, in practice it doesn't. It may be the case that, from your point of view, in theory in Sharia councils it doesn't, but in practice it does.
Well, I don't see it. But can I come back and answer this? Because it's quite an important point about the best-in courts. The legislation that Baroness Cox is promoting is not perfect by any manner of means. We know that, and I've said right from the beginning, it's all about consultation and so on. The interesting thing is the legislation is expressed in religiously neutral terms. In other words, it never mentions the word Sharia in there, or best-in courts or anything else, or ecclesiastical courts, deliberately, so that any religious courts that contravene the provisions of the legislation will be caught. It doesn't matter who they are. It doesn't matter whether they're Muslim or Jewish or anything else. And that's deliberately framed in those terms. And interestingly enough, in our consultations with the Jewish community, the Jewish lawyers that we have been consulting with welcome the provisions of the bill, because they say in those small areas of the ultra-Orthodox Jewish community where the provisions of equality are not provided for, then this will engender the debate within the Jewish community that needs to be had. So it's not seen as an attack on the Jewish community in any way. They have welcomed it and said we like it and are supporting it. And now actually one of them's offered to help write rewrite and amend the legislation as it goes through and to join the team. Because he has said to us, I welcome the debate within it's only the Jewish community that can have that debate, but it will give the opportunity for the debate. And in many ways we'd like to offer this as a service to the Muslim community too, and insofar as it impacts the Christian community.
You were saying, I mean, we have a rare moment of agreement here, because you were saying that actually this is a kind of catch-all legislation which may build up more resistance than they
For
imagine.
example, I won't say ultra-Orthodox, but with the Orthodox Bet Din, obviously there's liberal Jewish synagogues and Orthodox, but as far as the Orthodox Bet Din are concerned, in fact, if a member of the Jewish community wishes to bring an action, civil action in the secular court, they have to get the permission of the Bet Din first of all. So that means that the Bet Din are performing a quasi-judicial function, very much so, because certainly this isn't the case with the Sharia councils. Any Muslim can bring any civil claim, without having to get that permission beforehand. So that will hit them fair and square, if you like. The other thing is, I think, because this is a very important issue that has been raised, this matter of gender equality. Again, what has been misrepresented is, for example, in inheritance, that the male gets twice the share of the female. But that's only part of the picture, because the other part of the picture, part of the overall guidance of the Quran, is that the men in the family are responsible for the welfare of the women. So out of their share, they have to take care of all the female relatives in the family, and often these are very extended families. So they will end up, if you like, with less of personal wealth. Whereas with the female share, she can do what she wants with it. She has no responsibilities to the family. She may spend on the family voluntarily, but she has no, what we would call a legal responsibility under the Sharia. I think also one point I'd like to make, because it's very important, is that most people who come to the Sharia councils, and it is voluntarily, is that they want their disputes, because disputes arise in life, even with the best of people, they want them to be resolved in accordance with the guidance that has been sent through the last Prophet Muhammad sallallahu alaihi wasallam, through the Quran, through his example, through what he said and what his first community did in following him. They want their lives to be in harmony with that. And therefore they accept what is perceived by you as an inequality. They perceive it as a mercy. Now, I know that there are people who do not understand the Sharia and who are tyrannical in the way that they impose it on people. And in that aspect, I would agree with you completely that lack of due process is something that has to be removed as much as possible. It applies to every legal system. But in terms of the Article 9 rights, which the law of this land recognizes and guarantees, this bill, as presently framed, and I'm glad to hear that it still can be changed, as it were, is actually going to act to violate those rights rather than to uphold them.
We're moving towards the end of the programme now. So, Amra, the last question for you, really. If this were to become law, how would it affect in practice what you do?
I don't think it affects us a great deal, because what they're asking for is equality, which we already do. We act as an advisory body. When they come to us, we help them understand the teachings of Islam as well. We ask them to understand this is all totally voluntary. You can leave at any moment, any time, if you wish to. There is, no sort of nothing making them hang till the end. So personally, or in our Sharia Council, we have gender equality. We do not have any issues as such, but the issues that we do have is that since this bill came into existence since last year, we've heard a lot of things through the media, through newspapers, which is in fact maligning the name of Islam, Muslims, and is giving all that negative publicity, which, as you know, happens and fires back, and people get hurt and so on and so forth, which is how we feel that why is Sharia the main thing in the...
I'm going to have to stop you there because we've run out of time. Thank you for watching. Thank my studio guests for being part of that discussion, and I hope that you'll join us next week for another edition of the Politics and Media Show.